Hi, everybody. My name is Olivia Robinson, and I am your presiding judge for this year. And today we are going to be going over opening and closing statements. Now, whether this is your first year or your fourth year, I'm just going to cover as many of my bases as possible and try to answer any questions that y'all may have to hopefully make sure that we are as successful at state conference as possible. All right, so without further ado, I'm going to start sharing my screen with you guys. And just bear with me, I'm not the most tech savvy. Right. Perfect. Okay, so first thing we're going to be going over is opening statements. So opening statements is the first thing that you are going to say to your judge. It is your time to shine, you don't get interrupted, and basically you are going to set the stage for the entire trial. The prosecution will always go first and then the defense, and this is right after pretrial matters. So, of course, when we're talking about the opening statement, let's look at the rubric that your evaluators are given. So this is taken directly from the score sheet, and it says, a good attorney will use their time effectively and efficiently. So you're only given 3 minutes of time, and you need to do your absolute best in making sure that you're able to get out as much information as possible. They will lay out relevant facts of the case, describing all elements that they will prove later on. The best team will have their opening statements memorized. So, you're going to look at your facts, you're going to set your roadmap, you're going to prove what elements that you're planning on doing throughout this trial and showing your judge that you know what you're doing. And yeah, I understand that it may seem like a lot to have that opening statement memorized, but I mean, after your first trial, you're going to see that you are so much capable, like more capable than what you think. 3 minutes isn't that lot of long of time, and you're totally going to be willing to memorize it just based off on how often you're going to be practicing. So, first thing that I want to go over before going into how the specifics of the opening statements is the counts of this case. Because if you don't understand the charges, then you're going to have a lot of trouble creating an opening structured around them. So, the first charge that Willie Freeman has is he is charged with first-degree murder. So, it's given to us within our case that this big definition of first-degree murder. But I want us to focus on the first highlighted part. A person commits murder in the first degree when that person unlawfully and with malice aforethought causes the death of another human being. So let's break this down really fast. The few elements that you need to prove to get first degree murder is that it was unlawful, there was malice aforethought, and then it caused the death of another human being. All right, so first, it caused the death of Demon Frost. That's super easy. But what things that you kind of got to prove first is with malice. And it gives us the definition of malice. Malice is that deliberate intention to unlawfully take away the life of a human being, which is manifested by external circumstances capable of proof. Now, that does sound a little bit like gibberish, but basically what it's saying is malice is deliberate. Somebody must have what we think of as the motive to kill somebody else. And basically, the last part, which is manifested by external circumstances, which is capable of proof, is that you need to prove those circumstances that created the malice. Like in this instant, is it the fact that Devin put the business into so much debt that Willie ended up killing him? And of course, it goes through a lot more about what could be capable of murder when talking about robbery with a dangerous weapon. I did highlight kidnapping. It's totally up to you because maybe it is considered kidnapping of him putting into that freezer. But I mean, he wasn't taken from a different location, so it could be a little harder to prove. And basically, what it's saying is that these crimes of murder in the first degree, regardless of malice, is when that person takes another human life of being as a result from XYZ, and it gives this really long list of other things. But I don't really need y'all to focus on that. I think the biggest elements that you have to prove is the unlawful, with malice aforethought, and it caused the death of another human being. So, understanding that first count, there is also a second count. Willie Freeman committed the offense of presenting a fraudulent claim, and that the said defendant locked Devin Frost in the Shallott's restaurant freezer, and that when the defendant performed said acts, he did so unlawfully and with malice aforethought, caused the death of Devin Frost, and presented otherwise to collect life insurance benefit from the death of Devin Frost. Now, this is copy and pasted directly from your jury instructions and from your case. So, basically, what this count is saying, the first act sounds a lot like our definition of first-degree murder. And it's basically saying that Willie Freeman killed Devin Frost in order to collect life insurance. And that is a fraudulent claim because you can't kill somebody just to get their money. Do you know what I mean? Because he's trying to play it off that he didn't do that and he's collecting life insurance just out of accident, is what the defense is going to argue, but the prosecution is arguing that he killed with malice in order to get life insurance. So the definition that is given of a fraudulent claim, any person who presents or causes to be presented any false or fraudulent claim or any proof in support of any such claim upon any contract of insurance for the payment of any loss of who prepares, makes, or subscribes any account, certificate, survey affidavit, proof of loss, or other book, paper, or writing, basically a bunch of ways to say claim, with intent to present or use the same, or to allow it to be presented or used in support in any such claim, shall be guilty of a felony. Basically, it means that when you present a false claim and you're trying to prove it off as a real claim, with the intent to present or use it the same, that is saying that it's going to be guilty of a felony. So basically, with these two counts, you are unable to get count 2 without count 1 because you need to prove that he murdered Devin, A, and then that he wanted to use the life insurance from that murder. You know what I mean? You can't collect life insurance without proving that they murdered Devin because then there is no fraudulent claim based on this previous offense here. And with that, you got to prove those elements. And that is what your opening statement is laying out for the court. So let's talk into how we exactly write our opening statements after we understand our counts. First things first, you're going to want to offer a roadmap. Establish a brief backstory. Set a timeline. Introduce a theme. So with this brief backstory idea, is you kind of want to tell the judge what exactly has been going on from your perspective. Don't just give like this kind of facts where you're just like, and this happened, and this happened, and this happened. Use your persuasive language that you have been learning in your English classes. Really set the backstory that best fits your narrative as either the prosecution or the defense. And by doing this, you're going to be setting a timeline and also introducing a theme. I'm going to go a little bit further into theme later, but it's going to be your basically just bookmark end from your opening and your closing to really just rank up some points. So the second thing that you're going to do is establish some key witnesses and how they help prove your case. Establish the facts of the case each will testify to. So who are you going to be calling up to the stand? In what order? The order that you say them in your opening statement is the order that you should call them up to the stand, because that's the roadmap that you give in your opening statement. And you're not just saying, the prosecution will call Les Moore, Chris Riggs, and like that. You're like, okay, awesome sauce. What about them? Do you know what I mean? You're going to want to really introduce those key witnesses, show how they're going to improve your case, and we're going to go into that just a little bit more further on. Next, you're going to want to discuss the burden of proof. So, of course, our common saying, it is innocent until proven guilty, meaning the burden of proof is on the prosecution to prove that Willie Freeman is guilty, you know? So you would need to state the charges. That's a really big thing. And the elements needed to prove for those charges. Provide a clear and concise description of your side of the case. So when you state those charges and those elements, prove how you are going to give evidence of each of those elements. Prove how you're going to give evidence of the elements or show how you disprove each of those elements whether it means you're on the prosecution or the defense. Okay, so this is what I mean about the best openings kind of really do have this central theme, this hook. And obviously we did look at the rubric, and it's not stated in the rubric, but it does just kind of boost you up just a little bit, you know? Some examples of a theme could be a quote from a witness, that something that they said that proves that they're guilty. A common saying, a lot for a couple years back with the John Diamond case, it was all about this relationship. And so I use the common saying of love makes you do crazy things, stuff like that. Some people like to use a piece of evidence that is like their central thing that they kind of base it around. Like I think last year, a lot of people used the gasoline can with the Alex Buckley case, just as their central thing that they kind of focused on. A quirky but relevant saying. And you can also use the themes that you use in English class: love, legacy, respect, etc. A couple of teams who went to NJC this year used the theme of legacy because it was all about wills. So it doesn't necessarily have to be this overarching thing, but it's kind of just like a one sentence, 30-second thing that you use at the beginning of your opening and maybe the end of your closing as really just this tie a perfect little bow on your case and really just make it look pretty and to provide just a little bit of consistency throughout your entire trial. So be persuasive with your witness introductions. One of the ways I wouldn't do it, our witness, Les Moore, will testify to the finances of Willie Freeman's restaurant. That's perfect. That's perfectly fine. You know what I mean? That is what Les Moore is going to do. But you could then say, we will first call Les Moore to the stand to testify to their professional evaluation of the Shallot's restaurant and financial tensions involved in Devon Frost, which will prove Willie's motivation for the death of Mr. Frost. So you're both essentially saying the exact same thing. However, with our second option, we're getting that Les Moore is going to be entered in, hopefully, going to have a professional opinion. We're showing that there was some financial tensions with Devon Frost, which in turn proves our motivation. So you have given the judge that we're going to prove this element of our charges through Les Moore. That is offering a pretty consistent and effective roadmap. And you're going to do that for each of your witnesses. So this is an example when I send out this slideshow. We're going to look at it at the end of this presentation. So that's going to be our opening statements, and we're going to move on to their counterpart, closing statements. Closing statements is something that I always did when I was an attorney, and something that I believe is one of the most important parts of the trial, because it's your last hurrah to the judge, your Hail Mary if it's a really hard trial, or really it's just tying that perfect bow of every little trap that you laid out within the trial and proving that this is why you deserve the verdict. So for the defense, it's going to be 5 minutes long. And the prosecution, it's also 5 minutes, but they get to reserve up to 2 minutes for a rebuttal. And we're going to get into that a little bit further. So coming again directly from the rubric, from our scoring sheet, it says, similar to opening statements, so remember all the stuff that we talked about at the beginning, a good attorney team will use their time wisely to review the case and lay out everything they have proven to fit their narrative. Pretty straightforward, but it can seem like a lot when you're sitting in that trial. I think our best strategy when having a closing statement is taking notes throughout the trial of what you proved and what you disproved. Because yeah, you're gonna have a written out closing statement going into the trial, but who knows? Maybe you impeach somebody. Maybe somebody says something crazy and you're able to turn it to your side. You want to highlight those in your closing statements. So my best strategy when I was an attorney was to write a closing statement that was about a minute under the threshold. So for my defense, my closing statement that I write now was usually 3 minutes and 30 seconds to 4 minutes. It would really just depend. And so I could add in that other bit of content during the trial. And sometimes I would have to cut stuff out because I had 3 minutes of content in the trial and 2 minutes of stuff that I already wanted to say. And it really just all depends. So to write a good closing, I would start with your opening. Look at what the opening does. Use a similar hook. Reflect the language and the structure. Reestablish your theme. If your co-counsel brings up a theme within their opening statement, it is great to re-bring up that theme in your closing because you want to have that consistent, really effective use of time throughout both of your statements. Because yeah, it does show some consistency in your arguments. And a good way to think of this is in your opening, like we said in that example, we will prove with less more motivation. Really simple. In your closing, we proved that X, Y, and Z. And so basically, it's like they're little counterparts. We will prove, we did prove. Just to show complete consistency throughout your trial and throughout your case, showing that you are one team and one unit, and it really does help your evaluation scores. So a couple things that you should probably bring up within your closing statement. Strengths. Talk about what you proved and how testimony helps your side, whether that is direct examination, really just showing that this line of questioning proved this. This evidence piece that we entered proves this, showing your strengths and how you proved or disproved each of the elements in your case. Then you go to your weaknesses, not your weaknesses, your opposing counsel's weaknesses. Did you get important information in cross-examination? What did the opposing counsel fail to prove? Was the burden of proof met? And basically, during cross, did a witness say something that totally helped your side? Did you completely disprove their credibility? Did the opposing counsel even meet their burden of proof if you're the defense? Always bring up that the prosecution has the burden of proof. And if it wasn't met, make sure to say that within your closing statement. Another thing to bring up is impeachment. Always, always, always bring up witnesses you impeached and how that impeachment hurt their credibility. Because your attorney spent the time to impeach that witness. And if you don't bring it up in your closing, it's almost like that impeachment wasn't as important. When you bring it up in your closing, you're showing to the court that you did that well and that witness is untrustworthy, which can really sway a judge's decision. No new information. A closing statement. The whole idea of it is that it wraps out everything that was said in that trial. So if your closing is pre-written and there's something in there that didn't happen in that trial, make sure to cross it out. Maybe you just ran out of time and that certain element wasn't proved, or somebody said something crazy during a cross-examination that you really weren't expecting. Make sure to cross that out. You can only say testimony that it was used in the trial within your closing statement. So, prosecution can reserve up to 2 minutes for a rebuttal. This is a huge deal. I would always say to take that rebuttal. Whether you want to have the full 2 minutes is completely up to you. But taking that rebuttal, having that last word, can really affect the judge's decision as well as your evaluation scores. And you don't just want to go up there with this rebuttal and immediately right off the bat disprove, disprove, disprove. Because you have to still think of it as a way of having that closing statement persuasive language. So maybe start with a little bit of your theme. It doesn't have to be as long as the hook as you had to begin with. And you can be like, my opposing counsel consistently brings up the fact that Chris Riggs had shady business and was out to get Lou. And it's completely disproved everything. I don't know. Whatever they're trying to say. You then get to answer to that. But, Your Honor, when looking at the testimony from this witness, this witness, this witness, it is clear that that is simply not true. And what really happened is whatever you want to happen for your prosecution statement. So by saying stuff like that and using up that full time, It really does help. And to end off your rebuttal, which I think a lot of us sometimes struggle with, is you bring it back to almost the ending that you had in your previous closing statement. Just reword it just slightly. Don't just restate it again, because you already said that. You know what I mean? You want to use it time effectively, and you can just be like, you bring back up your theme, you use a little bit more wording, and then always end with, Your Honor, we ask for a guilty verdict. Stuff like that. Always ask for your charges at the end of your closings, whether you're prosecution or defense, and stuff like that. And it's really going to help your case. Another example, which we are going to look at now. So first, we are going to look at an opening example. So this is from some other competitors of previous years. So that's why there's these big black boxes just to block out their name. But you can see that you first started with introducing yourselves and who you're representing. So this is what I highlighted in yellow, as well as coming down to here in the second or third paragraph, is a quick background of the case. You can see that they use some very persuasive language with grappled, explosively, frustrations boiled over again, stuff like that, to really, instead of just being X plus B equals C, they use very persuasive, colorful language to, while they're giving a background, also helping their side of the case. And this right here, highlighted in red, is their charges. To convict Alex Buxley of arson in first degree, it must be proven that he intentionally lighting the fire or ignited the fire, knowing the building could be occupied. For the first degree murder, count 2, and they prove each of these, or they state each of these counts, as well as what is needed to prove them. They even provide a little bit of a definition down here. Then they provide a roadmap where they call 3 witnesses to the stand. They state what the witness will testify to. She will show you that Alex had the motivation to commit today's crime. Really what we talked about with that less more example. And then they end it with, based on the evidence you hear at the end of the trial, the prosecution asks to find the defendant, Alex Buckley, guilty of all counts. So this is an opening statement used by previous competitors, so it may not be the perfect opening statement example, and I'm not asking you to look at these examples and copy them word for word or even the structure of them, but they're kind of just used as an idea of how we use what we're taking in those presentations into a real life example. So just know these aren't rubrics, just examples. And then for closing statement, this was used at NJC this previous summer. So this gives a little bit of the background, and as well as they tried telling you this. So this is proving those weaknesses and strengths of their cases. They started that without right off the bat. But this right here, highlighted in the yellow, is their theme. They thought about the theme of legacy, and that is what they tried to bring forth within their closing statement. This right here, highlighted in green, is what the opposing counsel did wrong and what they did. See, he states that they attempt to depict Aaron as a bully, yet these claims lack foundation. We established Aaron's innocence through multiple points. And then they bring up a direct examination, what happened, and a cross-examination, what happened. And really just through these 4 points, it's stuff that happened within the trial that they bring back to center focus to help them prove their side of the case. And then they bring up burden of proof. If the opposing counsel cannot prove beyond reasonable doubt that Aaron coerced Cordelia into the 2018 when the will was written, the will must stand. So they bring back the burden of proof, as we talked about in our previous presentation. And again, they bring up the second argument, and as well, this is some testimonies from the trial where Cal admitted on cross-examination that Bergen manipulated Cordelia. That was stated during cross, so they weren't entirely sure if that was going to happen or not. That's what they thought was going to happen based on their line of questioning. So if Cal did admit to this within their trial, totally allowed to say it. If the witness did not, or they ran out of time to ask that question, the person writing or saying this closing statement would have to cross that out and would be unable to say it. And then the last thing that I wanted to highlight is to tell the judge what you want to happen. We respectfully request the court to invalidate the 2017 will and uphold the 2018 will and deed. They had a more of a civil case instead of a criminal case, but still it's that exact same idea. Another closing example is in here we have some definitions of Oklahoma state law about the charges. And then this highlighted in purple is what happened in the trial. As proved in today's trial, John Diamond did not have the malice intent to purposely hurt Trudy Doyle because this witness and this woman states this. This is further during the cross-examination, really just bringing up testimony in a way that is structured and organized in a way to prove your trial. That's what all these examples are really showing. Disproving elements highlighted in this blue here. And then this theme where love can make us all do crazy things, and John Diamond's love for Trudy Doyle is what caused him to protect her till her last breath. Do you see that persuasive, little bit roll your eyes, dramatic language here is what really helps your closing statement sing and have you get some pretty high scores on your evaluation cards. So these are my examples for openings and closing statements, and that does wrap up our presentation of them. If you have any questions whatsoever, feel free to reach out to me. I can read over some statements and help you. And I really hope that this does help explain a little bit more on what to do. Anyways, thank you guys so much for listening and tuning in. I hope to see you guys soon.